Committee on Judiciary to order. Mr. Secretary, would you please call the roll?
Assemblywoman Bilbrey Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner. Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Nguyen.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
And Chairman Yeager.
Here. I believe Assemblywoman Krasner has joined us as well, so could you please mark her as present? That means we have everybody here this morning. We do have a quorum. Thank you, members, for being here as close to 8 o'clock as possible. And welcome to the committee. Welcome to those who are joining us on the Zoom as guests, and welcome to those who may be watching on the legislature's website or on the YouTube channel. Before we get started on this morning's agenda, just a few quick housekeeping matters. For those of you on the Zoom, could you please mute if you're not speaking? And every time you speak, if you are a presenter today, could you make sure to please state your name, especially if you are responding to a question? That helps our committee secretaries with the minutes. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly acceptable, but we need to make sure we're being respectful of each other, of the legislative process, and of most importantly, our hardworking staff. And then finally, many members are using multiple devices to access this meeting: laptops, desktops, extra monitors, iPhones, iPads. So please don't see it as a sign of disrespect if members appear to be looking away during the committee meeting. They're most likely accessing exhibits or notes on the bills. With that behind us, members, we have 2 bills on the agenda today. We are going to take those 2 bills in order as listed on the agenda. At this time, I'm going to open the hearing on Assembly Bill 318. Assembly Bill 318 revises various provisions relating to estates. And before we get started with the presentation, I'll let members and members of the public know that there is an amendment that you can find on Nellis under the Exhibit tab, and I believe that's a friendly amendment. So to present Assembly Bill 318 this morning, we have our own Assemblywoman Marzola, and I know she has some guests with her to help us get through this trust and estates bill. So Assemblywoman, if you want to go ahead and get started, let us know who will be presenting with you. We'll give you a chance to make that presentation, and then we'll have some questions, I'm sure. So welcome to the Assembly Judiciary Committee virtual presentation table, and please proceed.
Thank you, Chair and members of the committee. For the record, I'm Assemblywoman Elaine Marzola, representing Assembly District 21 in Clark County. I'm here today to present Assembly Bill 318 for your consideration. With me today are the co-chairs of the Legislative Committee for Probate and Trust section of the Nevada State Bar, Alan Freer and Mark Noble. Both gentlemen are experts in their field. Just to give you a little bit of the background, Nevada is at the forefront of the estate and trust. To the extent this is because the legislature has consistently enacted cutting-edge provisions and updates. The bill before you today also updates our law as a result of the collaborative work with the Legislative Committee of the Probate and Trust section for the State Bar. Assembly Bill 318 primarily amends Title 12, Wills and Estates of Deceased Person, and Title 13, Guardianship, Conservatorship, and Trusts of the Nevada Revised Statutes, which are Nevada's laws pertaining to the administration of trusts and estates. This bill intends to clarify laws relating to trust and estates, adopt new laws to remain current as one of the top 3 leading jurisdictions of trust and estates in the United States, streamline the probate and trust administration process while including safeguards to prevent abuse, and provide additional laws in response to the COVID-19 pandemic with respect to electronic wills and trusts and the remote execution of such documents. Chair and members of the committee, there is a friendly amendment posted on Nellis for your consideration. At this time, Chair, I would like to hand the presentation over to Mr. Noble and Mr. Freer to go over the bill and the amendment.
Thank you so much, Assemblywoman Marzola. Welcome to the committee. Mr. Freer, Mr. Noble, which one of you would like to start first with the presentation? See who unmutes first, I guess.
This is Alan Freer. I'm unmuting to throw Mr. Noble under the bus. He's going to start the presentation. He'll be doing a presentation of sections 1 through 26 of the bill, and then I will be presenting on sections 27 through 44, and then addressing the friendly amendment that we circulated last evening. And with that, I'll turn it over to Mr. Noble.
And Mr. Noble, if you could unmute.
Hello, can
Yes.
everyone hear me?
We can hear you now. Thank you.
Hello?
We can
Hello?
hear you. Can you hear us?
Hello? Hello? Hello?
Mark, you're unmuted, so you can go ahead.
Okay. My name is Mark Noble. I'm co-chair of the Probate and Trust section legislative of the State Bar of Nevada. I will brief executive summary for my of the Nevada Revised. Those statutes relate to administrative in Nevada. This bill is intended to clarify the laws relating to trusted estates, adopt new laws related to in the forefront of the trust and estate jurisdictions in the United States, and Nevada is currently in the top 2 or 3. It also will streamline the probate and trust administration process, provide efficiencies, while including safeguards to prevent abuse. And the laws will also provide additional laws in response to the recent and ongoing COVID-19
Mr. Noble, I think you somehow muted yourself again, so we can't hear you.
Am I unmuted again? I apologize. I'm getting all these notices beyond me. I apologize to all of you, and thank you for your time and consideration on this bill. Essentially, though, sections 1 and 2 of the bill amends the declaratory relief statutes to provide relief or a way to seek relief for a principal or agent of a power of attorney. Section 3 of the bill provides that people, fiduciaries that become in temporary possession of property and are selling it will be exempted from the real property disclosure requirements set forth in the NRS. Section 15 of the bill amends nomination administrator provisions to require disclosure of certain information of persons nominating personal representatives upon written request to aid in the investigation if potential abuse is suspected. This bill or this amendment and law was specifically requested by Clark County Public Administrator to enable its office to verify the veracity and circumstances of the nomination. Some of the other provisions of the bill, I'll just skip ahead because I know we're short on time, provides Section 19 regarding the provides mechanism to personal representatives acting may act alone. Sections 21 and 26 amend the attorney's power provisions of 143 and administrative provisions to provide that they continue acting as a manager of a limited liability company, general partner of a partnership, or operator of an unincorporated business. And one other provision is the 21 and 26, Section 22, amends the ex parte provisions of 143 to exempt the public administrator's office from posting a separate bond when obtaining a restraining order to save taxpayer funds in acquiring a separate bond. Sections 24 and 25 amend the notice of hearing provisions and standing provisions of an independent administrator, specifically NRS 335 require initial notice of petition seeking independent administration be given to the public administrator and granting the public administrator standing to object to independent administration. Alan Freer will cover the rest of the bill.
Thank you, Mark. Alan Freer, co-chair of the Legislative Committee for the Probate and Trust section of the State Bar of Nevada. Thank you, Chairman Yeager, Vice Chair Nguyen, and other members of the committee. I'll present sections 27 to 44 of the bill and discuss the conceptual amendment provided last evening. In line with the four objectives, excuse me, of the bill addressed by Assemblywoman Marzola and Mr. Noble, I'm going to kind of address the latter half of the bill in the context of such objectives. With respect to the objective of streamlined administration, the streamlining of administration continues to be a mandate that we seek to follow, and it comports with the general directive of probate and trust statutes to ensure that administration is speedy and efficient with the least cost to the parties. Examples of this in the latter half of the bill appear in section 27 that permit the court discretion to set aside an estate from administration where you have a will that pours over into a trust because the administration of those assets will occur in the trust as opposed to a more costly probate proceeding. Likewise, changes to sections 40 and 41 of the bill regarding notice to creditors and trust proceedings will bring that procedure in line with the state procedure so you don't have differing procedures depending on whether it's a probate or trust proceeding, so as to avoid confusion and provide uniformity. With respect to clarifications of existing law, it's important that we allow these clarifications as, and I'll echo the comments of the prior two presenters, that Nevada is a top jurisdiction, and due to that, we have discussions, national discussions about Nevada's laws compared to other states, and sometimes in those discussions, they point out some areas of Nevada law that need clarification. So examples of that to afford uniformity of interpretation appear in sections 28 and 29. 28 clarifies statutory fees and when those are, and that those are per se reasonable. 29 provides for circumstances when an independent attorney when an attorney that is drafting a will isn't considered an independent attorney for purposes of the statutory undue influence. Section 30 amends the nomination of guardianship statutes, and I'll take a minute because we're into guardianship territory, but presently there are multiple laws that permit nominations of guardians in various documents, and those are found throughout the various parts of the code. By bringing those references into NRS 159.0753, this will allow recognition of all of the other statutory abilities to nominate guardians and harmonize that under the guardianship code section to avoid potential conflicts among those statutes. Section 33 clarifies NRS 163.004 to avoid confusion as to when a trust is revocable or irrevocable under Nevada law, which is a very important distinction for not only tax purposes, but also general spendthrift and administration purposes. Section 39 clarifies provisions in the decanting statutes as to when a trustee has authority. And then lastly, in that kind of section, section 42 of the bill clarifies circumstances when a divorced parent may represent a minor child in trust and estate proceedings, and it defaults over to the parent that has custody of the child as to allowing such representation. With respect to tax law, there are changes relating to section 31, which proposes a new statute that is added in NRS chapter 133. The IRS recently issued a revenue ruling that permitted trusts to include a power to reimburse the settlor for tax payments or liabilities. And so this statute incorporates that permitted federal tax law power into Nevada law. Additional protections, while we try to streamline the administrative process, there needs to be a balance in providing protections to curtail abuse and protect beneficiaries and creditors of the estate. In that line, section 35 is one example of protections for beneficiaries where it requires a court order before a trustee can divide or combine trusts if the trust instrument doesn't expressly grant that power. Similarly, Mr. Noble had referenced some sections that were drafted to allow notice to the public administrator. Sections 44 through 46 are similar in vein. In those, it affords similar notice and standing and information to permit the public administrator to better protect estates, especially in instances where an intestate estate is being administered by a non-heir or next of kin. Lastly, I do have the amendment I'd like to talk about. The conceptual amendment we provided last evening. It fixes a couple errors that were encountered when drafting the bill and includes 3 provisions that were omitted from the first printing. Briefly, those amendments are as follows. Amendment to section 19 to provide for situations. The original part of section 19 did not have a situation where if documents weren't requested, what the timing was to turn over property belonging to a state. So that adds a provision where if you aren't requesting additional documents, you're required to turn it over in 10 days. The amendment to section 31 clarified language to avoid unintended tax consequences. And so, as I discussed, that's in line with the revenue ruling from the IRS. And so we needed to track that language. Sections 41 and 39 make changes just to ensure that the administration process occurs and includes the language that was originally intended for the bill. The new amendments to sections 48, 49, and 50 were amendments that were proposed but not included in the original draft. Real quickly, section 48 amends NRS 139-100 to provide similar notice provisions on initial hearings to require and to enable the public administrator to receive notice of those probate petitions where the person seeking appointment is neither the spouse, heir, or a nominee of the spouse or heir, and that's designed to curtail potential abuse. Likewise, the amendment to create a new section 49 changes a shall to a may in NRS 143-350 to permit the probate court discretion when it determines whether or not to grant independent administration of estates. And lastly, the amendment to create a new section 50 adds an additional provision in the sale of property during independent administration. This is another safeguard statute. When an administration is occurring without court supervision and a sale is less than 90% of the appraised value, the requirement would be to obtain written consent from all of the interested persons. And if such consent is not provided, then the personal representative must go through with a judicial sale as opposed to an independent sale. With that, I'll be happy to cede the floor and answer any questions regarding the bill.
Thank you so much, Mr. Freer. Mr. Noble. Mr. Noble, we had some difficulties with your audio at portions of your testimony, but I wanted to let committee members know, I failed to mention this, but for committee members and members of the public, there is an exhibit under Nellis that is an executive summary from the probate and trust section of the State Bar that does go through the sections of the bill and explain what they do. So if you were unable to hear some of the audio from Mr. Noble and you're interested in particular sections, I wanted to reference that for the committee. I had a couple of questions I'll just kind of start out the gate with, and I think, Mr. Noble, the first one is probably for you. It's in Section 3 of the bill, which is on page 7, and essentially we're adding, I guess, an exception to subsection 1 about the need to complete a disclosure form. And my question, I guess, in the new language that we're adding there, it essentially indicates that if there is a fiduciary taking temporary possession solely to facilitate the sale of the property, that they don't have to fill out, I guess, we'll call it the disclosure form regarding residential property. And my question was just, is that exception going in there because this person just wouldn't have personal knowledge adequately to be able to fill out such a disclosure form?
Is that question for me?
Yeah, I think so, because I think
Sure,
it covered one of
sure.
the sections you covered.
Yes. It's because they would be in temporary possession of the property. They may have never even lived in the property or never stepped foot in the property. Potentially could be from out of state, personal representative or heirs, and it puts an undue burden on them. And it would create a situation where they would have to spend quite a bit of, I would think, money on due diligence in order to properly fill out a disclosure form like that.
Thank you, Mr. Noble. That certainly makes sense and was in line with what I anticipated your answer would be. Mr. Freer, I think the next question is probably for you, and it's in the new section 50 that's in the amendment of the bill. And I noticed the language at the bottom there indicates that if the sale of real property is less than 90% of the appraised value, essentially all interested persons have to consent in writing and must otherwise seek confirmation of sale. And then it references NRS 148.060. And I just wondered if you could shed a little bit of light on what confirmation of sale under that statute means and how that works in the real world.
Sure thing. So we'll start with the independent administration of the estates, in which section 50 is located. When a court grants a personal representative independent administration of the estates, it typically speeds up the administrative process, but it gives the personal representative a lot more authority to go in and administer the estate without receiving court orders approving certain actions. One of those is a sale of real property. And so subsection 2 of the amendment that we're going to have, and I'm going to pull that up real briefly. Subsection 2 of NRS 143-380 outlines what typically is required in a normal probate sale process. That includes publication of notice, providing notice of how much the broker's commissions are going to be, finding a deal that's over 90%, and permitting the court examination of the contract. And in an informal probate proceeding, that's not required because you're typically dealing with family members that get along and there aren't issues. Now, the one protection that we wanted to apply is if you do fall under that 90%, of the appraised value. Then you need to get all of the family members involved, or if there are any creditors involved, and they have to look at the sale and approve the sale price. If not, then you've got to go back to a regular probate court sale proceeding, wherein you'd have to provide publication, which then brings in potential bidders, and bring the sale to the court for approval during a hearing process.
Thank you, Mr. Freer. And if I could just sort of restate that to make sure I understand it. So essentially, this is kind of a streamlined procedure when you're not going through the formal process. But if it's going to be a sale less than 90%, if everyone doesn't agree with that, then it would have to go through that more formal process where all the sort of bells and whistles of the estate, the liquidation of the estate would happen.
You're absolutely correct.
Okay, thank you. Do we have other questions from committee members for our experts on the Assembly Bill 318 that is in front of us this morning? I know there's got to be a couple out there, or not. Assemblywoman Cohen, did you have your hand up?
I did, Chair. Thank you. I just have a couple for either of the presenters. Your presentation in the bill touches on some issues with family law and some issues with guardianship, and I just want to make sure I understand the process that through the state bar, the different sections of the bar do vet. If you've come in support of this bill, that means that all of the different sections of the bar have vetted the bill?
Yeah, this is Alan Freer. So the answer is yes. So the state bar process, when a section gets approval to present a state bar bill, what happens is in July or August of 2020, the sections circulate the different bill text around between the various sections of the state bar, including family law and elder law sections. They then have a comment period to provide any potential questions or concerns, and whereupon at that point there's a determination as to whether or not sections have problems with the bill. With respect to this bill, it was circulated. No other sections had any issues with it. And so then when we went to the state bar, the state bar unanimously approved the text you see before you in the bill as a section-sponsored bill. Just specifically with respect to the family law and guardianship questions, I will make a representation that the change in the guardianship code of 159 doesn't provide any substantive change to the guardianship laws. What it does is simply denote where the other sections of where nominations of guardianship currently exist and can occur under Nevada law, just so there isn't ever an issue where the court is wondering if one nomination trumps another or one is effective or not effective. It just references that all the various Nevada law nominations of guardianship are recognizable.
You, and then Chair, if I could have one more question.
Please go ahead.
Thank you. So my other question has to do with something I noticed in section 19, and frankly, I don't know if it's in other sections. It just didn't catch my attention. The timeline, there's a reference in 19 sub 2 to 10 business days, and I'm just wondering why it's business days and not judicial days versus calendar days, and if that might make things more confusing. Because I don't know exactly what a business day is, but I know what a judicial day is, and I know what a calendar day is. So is that intentional to use the term business days?
Alan Freer, on behalf of the Probate and Trust section. Assemblywoman Coleman, you bring up a good point. That was just a drafting choice. There wasn't any specific intent or reasoning for that. I would be fine including as part of the amendment, just changing that to judicial days, or 10 judicial days or 14 calendar days would be similar.
Okay, thank you.
We'll go next to Assemblywoman Kasama.
Sorry, I have to scroll that mouse from one screen to the other. So thank you, Chair. Can you, I'm not an attorney, and I know we have plenty of attorneys on this committee, but can you perhaps give a 30,000 foot level as to, this seems like a lot of changes. I believe there were changes in the last session as well. What were the biggest problems that we had here that has brought about all these changes?
Yeah, Alan Freer, on behalf of the Probate and Trust section. I would start with a little humor. The changes in this session's bill is about half of what we've normally had in the prior 4 or 5 sessions that I've been a co-chair of the committee. I'm sure Chairman Yeager is very happy that we have a shorter bill today. But from the 30,000 foot view, this session was different really because of 2 issues. The most important meat of this bill occurs in sections 14 to 19, and that really was when the pandemic hit. We really needed to shore up what electronic trusts and wills and electronic notaries, because that's almost more important, is allowing this remote notarization of documents during the pandemic occur. And so that provides, those sections are the largest chunk or meat from a 30,000 view of the importance. The other aspects of it are more kind of what I'd call fine tuning or tinkering, where you kind of, especially when you get into tax law or complex situations, a turn of a word or a particular ambiguity on a line in text can have kind of a cascading or domino effect on whether or not it is properly administered, or whether or not tax laws allow for recognition of an exemption or not. And so most of the other changes with respect to that are kind of fine tuning changes, just to kind of keep, we've got a good thing going, we've got a good system of laws going with respect to trusts and estates, and those fine tunings are just kind of to keep us running, at optimal efficiency.
And then in the past couple sessions, there was just a lot of, it sounds like abuse with elder care, transferring of estates. So this is a large cleanup over the past few sessions.
Alan Freer, yes, that's also correct. One of the things we're cleaning up also in terms of a big chunk is the notification provisions to the public administrator. In line with some of the administration statutes, there were situations where non-heirs, non-family members, non-spouses were seeking appointment, which they can do under the statutes. Ever since we adopted the code, I believe in 1896 from California, you've had non-family members able to seek appointment. But here, because of some of the laws, there was kind of a little mouse hole that was allowing for some abuse in trying to find distressed properties and sell those without the family members really knowing full well what was going on. And so by allowing the additional notification to the public administrator, it provides an extra check and balance where the public administrator who's in the court system fairly regularly for trusts, for probate and trusts, can kind of get a sense of if anybody's trying to abuse those statutes.
Thank you.
And if we could maybe stay on that topic, Mr. Freer, if you had mentioned in your testimony that there was a federal tax ruling that led to some of the drafting of this, and if we could, maybe you could stay at this 30,000 foot view and just give us a sense of what that federal tax issue was and what the bill does to address it.
Right, and I have to give you a 30,000 foot view because I'm a trust and estate litigator as opposed to a tax attorney. But so we're talking about Section 31, and in Section 31, what happened is the IRS came out with a revenue ruling, which essentially is a question where the IRS is receiving several inquiries about, hey, if we give a trust maker this type of power, do we still allow it to be outside of his estate? And so what we're dealing with is completed gifts, And so when you set up certain trusts, you can kind of freeze the tax portion of that in time, give it to the children or charities or other beneficiaries without having it taxed in that person's estate when they pass away. But with that comes additional what are called retained powers. And the IRS has been very selective on which powers are okay for that trust maker to take and which powers are not okay. And what Section 31 recognizes is the IRS has said, hey, if a trustee has the power to reimburse taxes that the settlor has incurred by way of that trust, then reimbursing the settlor for those taxes is not going to cause a recognition of that trust in his estate when he passes away. And so it's allowing more kind of reimbursement of taxes in a certain mechanism without jeopardizing the entire trust back into the estate.
Thank you, Mr. Freer. Any additional questions from committee members on Assembly Bill 318? Assemblywoman Summers Armstrong.
Thank you, Chair Yeager. Thank you, Mr. Freer and Mr. Noble for your presentation, and Assemblywoman Marzola for bringing this. I think I know the answer to this, but I'm going to ask just to make sure that I'm clear. In Section 29, where it amends, I'm looking at the executive summary, and it says it amends the definition of independent attorney under a certificate of independent review, and you list the NRS, and it's mostly saying that the drafting attorney, I'm going to assume that's the attorney that drafted either the will or the trust, may qualify as an independent attorney so long as he or she is not a transferee or served as the attorney for a transferee. So when you say transferee, does that mean a person who is entitled to receive, or the person who is moving assets within the trust to people who are inheriting or have a stake in the trust? If you could kind of just clarify that for me. And is this an attempt to make sure that that attorney is not drafting a trust or will that they could somehow benefit from?
Do you want me to, can you hear me?
Yeah.
Okay. Essentially, the transferee is the recipient of the property. So the attorney could not be the attorney for the recipient of the property. And they are able to provide a certificate saying that the person making the changes to their will or trust are not under some type of undue influence for the recipient of the property. Did that answer your question, or do you have more?
Yes, it does answer my question. And I would like to follow up, Chair, if that's all right.
Please go ahead.
Thank you. This is Chandra Summers Armstrong, Assembly District 6. So the transferee, would that imply that they are the only person who could be receiving a benefit? Could they be transferring to other people or is that a different, is that an administrator? Is that a whole different title?
The transferee would be the recipient of the property only, is my understanding. And Alan, I'd let you jump in here if you have any other ideas. The attorneys are prohibited by professional code from receiving any property of a will or trust they draft. So the attorney could not be ever a recipient. And of course, the attorney could not be representing the recipient in this process of providing a certificate of independent review.
And this is Alan Freer. Just to clarify, so this section of statutes, what Nevada has enacted is a statutory presumption of undue influence, where under certain circumstances, if a will is drafted and it meets these, it's presumed void because of kind of red flags in the drafting process. One of the ways around that statutory presumption is to have an attorney who is completely separated out and independent from any of the beneficiaries who are receiving gifts under that will or trust, to be able to advise the person making the will or trust and ensure, kind of ask questions similar to, hey, you've got a gift going to this particular grandchild that's much larger than other grandchildren. Tell me about that gift. Is anybody putting pressure on you to make that gift, etc.? And after they are able to certify that, they provide a certificate of independent review saying essentially that they've gone through all of the provisions to do the best they can possible to make sure that that really is what the person making the will or trust wanted without interference or undue influence from other family members, caregivers, etc. And so, but in specific answer to your question about the transferee, yes, there is another statute in that section that prohibits dependents or affiliates of the drafting attorney from receiving any of those benefits as well.
Thank you. You're welcome. Do we have any other questions from committee members? Okay, I'm not seeing additional questions. And Mr. Freer, I will say thank you for cutting the bill in half this year. So it was still quite a bit to get through, but anyone who's on the committee the last couple sessions certainly remembers. I think we had one that was over a couple hundred pages at one point. So this one was a little bit more manageable. And so we'll ask you two and Assemblywoman Marzola to just sit tight for a moment. We'll take some testimony on the bill, and then we'll have a chance to do some wrap up after we do that. So at this time, I'm going to open it up for testimony in support of Assembly Bill 318. Is there anybody on the Zoom with us who would like to testify in support of Assembly Bill 318? If so, if you could.
Testify?
Oh, I'm sorry. One moment, broadcast. Is there anyone on the Zoom who would like to testify in support? Okay, I'm not seeing anyone. Broadcast, could we go to the phones, please, and see if there's anybody there who'd like to testify in support?
Yes, I apologize, Chair. To testify in support of Assembly Bill 318, press *9 now to take your place in the queue. And we will begin with the caller with the last three digits of 332. Caller with the last three digits of 332, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Hello, this is Robert Tellis, the Clark County Public Administrator. My last name is spelled T-E-L-L-E-S. Again, my name is Robert Tellis, or Tejas. I'm the Clark County Public Administrator. And I am grateful to the probate and trust section of the Nevada State Bar for taking up a lot of the provisions that relate to my office. A lot of these provisions are created in an effort to ensure that families are protected, that there is more transparency in the process. Also, there are certain provisions there that will assist our office in doing a better job for our Nevada families. Again, I think it's very important, especially talking about the issues related to the Independent Administrations Act. There have been certain situations, while not necessarily unlawful, are of serious concern, I think, to Nevada families that will be addressed by this legislation. And I'm looking forward to making sure that we've got these safeguards in place in our laws to make sure that these types of things in independent administrations are of the that are done in good faith, and that if they are not, there are mechanisms for ensuring that that such types of transactions can be stopped. And again, I'm very grateful to the Trust and Probate section. I'm very grateful to Assemblywoman Marzola for taking up this bill. And of course, I'm very grateful to the Nevada Legislature for your consideration as well.
Thank you for your testimony and support, Mr. Tellis. BPS, is there anybody else who'd like to give testimony in support?
To provide testimony in support of Assembly Bill 318, please press *9 now to take your place in the queue. Chair, at this time, there are no more callers wishing to provide supportive testimony.
Thank you, BPS. I will close testimony in support. I will now open testimony in opposition. Is there anybody on the Zoom who'd like to testify in opposition? If so, if you could turn your camera on, unmute, and let me know. Okay, I'm not seeing any activity here on the Zoom. BPS, could we go to the phone lines to see if there's anybody there in opposition?
To provide opposition testimony on Bill AB 318, press star 9 now to take your place in the queue. To provide opposition testimony on Bill 318, press star 9 now to take your place in the queue. Chair, there are no callers wishing to provide opposition testimony.
Thank you, BPS. I will close opposition testimony. I will now open neutral testimony on the bill. Is there anyone on the Zoom who'd like to give neutral testimony? Don't see any activity here on the Zoom. BPS, could we go to the phone lines to see if there's anybody there in neutral?
To provide neutral testimony on Assembly Bill 318, press star 9 now to take your place in the queue. Once again, to provide neutral testimony on Assembly Bill 318, press star 9 now to take your place in the queue. Chair, at this time, there is nobody wanting to provide neutral testimony.
Thank you, BPS. I will close neutral testimony. Assemblywoman Marzola, I would hand it back over to you and your co-presenters for any concluding remarks on Assembly Bill 318.
Thank you. I would just like to take this time to say thank you, Chair and members of the committee, for the opportunity to present this Assembly Bill 318 and hope to get your support in this really important legislation.
Thank you. Mr. Freer, Mr. Noble, anything else you'd like to add?
This is Alan Freer, no Chairman Yeager. I'm just happy that I didn't have to provide a definition of the rule against perpetuities this session.
Thank you so much. We may have you come back to do that at some point. We'll see. I know the committee is waiting with bated breath for that presentation. But I want to thank the two of you for joining us here, Mr. Freer, Mr. Noble. And committee, obviously, this is a pretty dense bill. So if you do have additional questions after looking at the executive summary that was provided, please feel free to reach out to Assemblywoman Marzola as well. And Mr. Noble, I saw that you unmuted. Do you want to make any concluding remarks?
No, I just wanted to thank everyone. Apologize again for my problems with the Zoom on this. Again, thank all of the committee members.
Thank you. It's no problem. We are working through these audio and technical challenges as best we can. So it's happened to all of us somewhere along the way. And again, appreciate you two for being here with us this morning. We hope you have a great rest of your day. And we will now close the bill hearing on Assembly Bill 318. And committee, we're going to move right along to our second bill on the agenda, which is Assembly Bill 339. I will now open the hearing on that bill. Assembly Bill 339 makes various changes relating to domestic violence. Committee members, members of the public, just like we did on the last bill, there is an amendment that you can find up on Nellis under the exhibit tab that makes a few changes to the original bill. And we have our own Vice Chair Wynn here with us to present Assembly Bill 339. So we'll give her a chance to do that, and then I'm sure we'll have some questions. Vice Chair Wynn, welcome back to the virtual presentation table, and please proceed.
Good morning, Chair Yeager and committee members. For the record, I am Rochelle Wynn, and I represent Assembly District 10. Today, I will be presenting for your consideration Assembly Bill 339. Essentially, it creates a specialty court to help facilitate treatment programs for individuals convicted of misdemeanor battery domestic violence. I will be presenting off the amendment that was emailed last night and is actually posted on Nellis now. But at this time, for some background information, I am going to turn this presentation over to Nicole Salcedo. She's one of my interns this session, and I will turn it over to her and remind her to introduce herself and state her name for the record.
Good
Good morning, Chair Yeager and committee members. For the record, my name is Nicole Salcido, and I am a student at UNR and intern for Assemblywoman Wynn. Today, I will be helping Assemblywoman Wynn present AB 339. With that being said, let me begin. Specialty courts are problem-solving court strategies designed to address the root causes of criminal activity by coordinating efforts of the judiciary, prosecution, defense attorneys, law enforcement, and mental health/social services/treatment professionals. They are rigorous, requiring frequent drug testing and court appearances, along with tightly structured regimens of treatment and recovery services. Specialty courts offer an alternative to incarceration. The goal is to break the cycle of the revolving door syndrome and support participants to achieve stability by promoting responsibility and accountability and teaching participants to become productive citizens, which in return criminal recidivism and provides for better, healthier communities. Specialty courts can be also helpful in freeing up resources of the lower courts where many of these cases would normally be tried. This allows many to realize the promise of a speedy trial and resolution. Nevada implemented the first of its 46 specialty courts in the early 1990s and has been a pioneer in the field ever since. National research shows they reduce crime by as much as 45% more than other methods, producing an average $2.21 direct benefit to the community for every $1 invested. When more high-risk offenders are helped, the return of investment can be $4.13 per dollar invested. Some additional benefits of implementing specialty courts are increasing public safety, reduction in criminal recidivism, improvement in quality of life for participants, and restored positive community involvement. While most specialty courts address nonviolent crime, domestic violence courts are part of a trend in the emergence of courts that address violent crime. The first domestic violence court started in Miami, Florida in 1992. Currently, there are an estimated 300 domestic violence courts nationwide. Domestic violence courts create procedures to promote victim safety, use and collaborate with community-based organizations, and ensure accountability for domestic violence offenders. I will now turn it back to Assemblywoman Wynn. Thank you.
Thank you, Ms. Salcedo. I appreciate you presenting a little background information on specialty courts. And for those of you that are new to this committee with me, just a little bit of a background. I've participated in specialty courts from the time I was a brand new lawyer. One of my first jobs, in fact, my very first job, I clerked for Judge Jack Lehman, the late Judge Jack Lehman, and he had started the very first drug court in the state of Nevada, and only the second in our nation. So Nevada has a long history of establishing and working specialty courts. There are so many specialty courts that are in our courts. We have veterans treatment courts, we have mental health courts, we have women in need courts, we have juvenile drug courts, there's so many. And when you start to learn about the success of investment in these programs, you see that they cut down on recidivism rates, they help with actual treatment, and they are really, really hard to get through. This bill creates some enabling language. Currently, this is one of the crimes, battery, domestic violence, the misdemeanor, is one of two that I can think of, criminal charges where you cannot get a reduction. The prosecutors don't have discretion. They are tied to a very specific structure. So under current statute, if I catch my husband cheating on me and I dump a drink on him, I will be charged with battery domestic violence. That is battery domestic violence. And under those current circumstances, I will be sentenced, I will be convicted, I will lose my Second Amendment rights. I will have to do the standard 6 months of counseling, one time per week for 26 weeks. I will have to pay a mandatory minimum fine of $340. And I will also have to do 48 hours of community service in addition to spending 2 days in jail. If correspondingly someone beats up their spouse and they are injured and they are beaten and it is a ongoing problem, that is the same penalty under law for that individual as well. Prosecutor, and you'll hear from them during support testimony, and they could probably answer any questions you might have about their role in this. If you're charged with murder, they can take into consideration all of the circumstances. They can take into consideration your mental health history. They can take into consideration like mitigating circumstances that may be morally mitigating, but under the law are not. And they can reduce that charge. They cannot do this in this circumstance. We have established specialty courts in our state that have shown that they have been successful. They use best practices, they use evidence-based practices, they really reach out to community organizations and engage in a more holistic approach in doing this. And that is what this bill allows. It allows that enabling language. Currently, the only people that can participate in a specialty court when charged with a battery domestic violence misdemeanor are veterans. We made changes, I believe, in 2017 that allowed veterans only to participate in a veterans treatment program, which is another one of our specialty courts. Again, this is enabling language. It gives the courts yet another tool if they want to establish these courts to provide an incentive that's evidence-based, that's financially and fiscally responsible for our communities, that can show results. So that kind of gives that. There are some substantial amendments that were emailed out to committee members yesterday. I can answer any questions about that. Essentially, battery domestic violence is a little bit more complex. I had taken some of the language from some of the other specialty courts as far as how they are formulated and how they exist. But there is some crossover and there is some other issues when it comes to the ability to seal those records. I always tell my clients when I come into contact with them, a first offense battery domestic violence is a misdemeanor. A second offense is also a misdemeanor, but it's enhanceable. And a third offense within 7 years is a felony. It does carry with it mandatory 1 to 6 years in prison. So there is like these enhancing penalties for this type of charge. And for that reason, an automatic sealing is not necessarily accurate because we do want to be able to have that case open to a certain extent for a period of time if the person does reoffend. We want to be able to go back and charge them with the second offense if it's within that 7 years. So we've added some conditional dismissal language, and this is similar to the language that's used in the Veterans Treatment Program, as well as our DUI specialty courts. With that, I can go through, answer. I'm sure people have other questions about this. So at this time, I will just open it up for questions.
Thank you so much, Vice Chair Nguyen, and thank you, Ms. Salcedo, for your remarks. You did a wonderful job laying the groundwork for the bill. I have a couple of questions, but I'm going to go to other members first, and I think Assemblyman Wheeler looks very eager with this question. So Assemblyman, please go ahead.
Thank you, Mr. Chairman. My fingers were broken. I couldn't type you a message. But Madam Vice Chair, you made a comment that kind of got to me that the penalties would be the same for dumping a drink on someone as for actual physical violence there. And I'm wondering, one thing I don't see in the bill is, wouldn't it be also good, I should say, to add a little more judicial discretion in as far as punishments are concerned, whether they go to the new specialty court or not? Because I don't see that in here.
Well, I will tell you, if you pull up the bill and if you go to page, I think it's page 11, you will see the section in there. And what it also does is it eliminates the section that ties our prosecutors' hands. I can tell you that in looking at this, I had looked at this from a couple of different perspectives. I had met with members of our law enforcement because I thought, maybe we should go back and give them more discretion in the field to determine, because we used to have a situation where we trusted police officers on the field to make those kind of determinations. Like, is this a bar fight? Is this like a battery domestic violence? Like, what can I do in this situation to diffuse this? I know in talking with them, they have been operating under this model for probably about 16 years, I believe. And so these are some of the more dangerous calls that they go out to. So sometimes it is a lot easier for these officers to just arrest the primary or the person that they think is the initial suspect just to diffuse the situation. So then I talked to our prosecutors across the state and said, hey, what can we do? What kind of tools can we give you to, weed out the good cases and, dismiss old cases or resolve other cases as you see fit? And so if you see that section, what also authorizes the specialty courts to exist is the fact that it also returns discretion back to prosecutors. So if they see that case with the drink being dumped on someone's head, they can choose now to dismiss it. They can choose to reduce it to a simple battery or a disorderly conduct or any one of those kind of things. So they have that option now under this language to be able to look at that and make that kind of determination on whether or not they want to plea bargain or reduce those charges, if that makes sense.
It does, and I thank you for that. I'm sorry I didn't see it on page 11. Matter of fact, I see no new language on page 11, but
it's just crossing out language if you see it. And I think it's on page 11.
okay. Nope, but I was looking at the amendment, actually.
Oh, yes, it is in the original text of the bill. If you scroll down, it is under...
Well, that's all right. You can just give it to me offline. I don't want to hold up the committee hearing.
Do you have any other follow-up questions, Assemblyman Wheeler?
Nope, that's it. Thank
It's
you.
on page 12.
Oh, I got it. Okay, thank you.
Okay, who else has questions for Vice Chair Wynn? Assemblywoman Hardy?
Thank you, Mr. Chair, and thank you, Vice Chair, for bringing this legislation and putting so much thought into it. So my first question, what would it take to actually have these courts established so that prosecutors and such, have this option?
Part of, there are a couple of ways that we can establish specialty courts. There's pre-prosecution diversion programs. There are post-plea type programs, and that's what this would be. You would have to enter a guilty or NOLO plea. So you would have to enter a plea to the charge of battery domestic violence first offense. It would only apply to a first offense. Like in many other specialty courts, you would have to go under a process of assessment and evaluation to see whether or not you were appropriate for that type of program. And then the program as it exists, part of me, I wanted to make it enabling language because I recognize that we are having some economic shortcomings, although I would encourage all of our courts to do this because I think the specialty courts, like you saw during the presentation, can sometimes save us for every dollar invested up to $4 in savings. So they will do it. And talking to some of these judges, some of the more urban areas have courts that are just dedicated to handling DUIs or handling battery domestic violences. And so we do have DUI court programs, but I think authorizing these languages, I bet there are judges out there that will want to do this. I think they see a need in their courts. They see the sheer number. I think we heard during one of the City of Henderson's bill about how many battery domestic violence charges there are in our state, in our different communities. This gives them another option to be able to handle these cases more appropriately than just arresting and giving standard conditions to all people across the board. So I would hope that they would do this. Again, it is just enabling language, and I would hope that people would take up the cause. And they have in the past. We started off with just drug court, and now we have mental health court, and we have WIN court, which is women in need. We have a YO court, which is the youth offender court. So people have taken on, these types of charges in other courts. And I trust our bench to, they've been on the forefront of specialty courts in the past. And so I think that they would take up that mantle as well.
Thank you. And could I have a follow-up?
Yes, please.
Thank you. And that was my second question. This is for first offense, misdemeanor, battery, domestic violence. And I appreciate that. And I agree that we need to give judicial officers in the courts discretion to consider the circumstances, like you said? Was it just a drink thrown, or was this serious injuries and whatnot in each situation? Could you just go over it briefly, like section 4 on the amendment, where you made some changes that would allow, for the victim to be heard before, someone would be admitted into such a program?
Yes, I can go ahead and do that. Hold on one second. I have all these screens yet. I still haven't managed to manage all the screens. 1 second. So if you look at the amended language, and that's on the amendment that's on Nellis, you will see that in section 4, I've taken out the part. I'm not sure why that was in there. I didn't want it to be a situation where you went to trial and you were found guilty, and then you decided that you wanted a specialty court. So it does have to be someone that tenders a plea of guilty or guilty but mentally ill or nolo contendere. And so people, non-lawyers, no contest or nolo contendere just means you're not admitting the facts of the case, but you are admitting that you would be found guilty if you were to go to trial. It is a conviction, just like a plea of guilty. So, but I took out the part about being found guilty or found guilty after, like, essentially a trial. I also wanted to put in there that there was argument from both parties. So both the defense as well as the prosecutor have the opportunity to argue for why this would be appropriate before a court decides to suspend the proceedings and kind of put a pause on the person's plea and allows them to complete this program. Section 2 talks about how the court shall allow the state and the victim to reasonably be heard before the court considers assigning a defendant to a program, and shall consider the safety of the victim as a factor in determining whether or not to assign the defendant to this program. I will tell you, in talking with some of the victim advocacy groups, I am contemplating and I am looking at language to also further indicate that the person has to be accepted into the specialty court, and that there's a process for how that specialty court is established and what kind of guidelines that they would need under there. Most of these specialty court statutes are pretty vague and broad, but we do have some guidance in administrative codes and other areas where there are batterers treatment programs. And I just want to make sure that there's clarifying language that still gives authority to the courts, but also works within the existing structure that we have in other areas of law. And how that's compatible, I'm just waiting to hear from legal on how we incorporate some of that additional protection language in there. Additionally, if you've been previously convicted of a misdemeanor battery constituting domestic violence, or you've even completed a program in the past, you don't get to keep coming back to this program. So there are some limitations for that. Additionally, in subsection B, you'll see the defendant has entered into a plea agreement with a prosecuting attorney. So let's say you're initially charged with a felony and it's plea bargained down to a misdemeanor first offense, battery domestic violence. You can't then also apply for a specialty court to get that dismissal. And again, if you were convicted at trial, which I think is just clarifying language from the subsection 1 as well.
Thank you for going over those details. I appreciate that.
All right, we have more questions. Here's the order we're going to go in. We'll start with Assemblywoman Summers Armstrong, then Assemblywoman Cohen, then Assemblyman Orentlicker. Assemblywoman Summers Armstrong, please go ahead.
Thank you, Chair Yeager. Chandra Summers Armstrong, Assembly District 6. Thank you, Assemblywoman Wynn, for this bill. And I just have a couple of little questions. So you spoke about working with community groups for sort of a restorative justice as part of the process of therapy, if you please. Have you spoken with any of our local community groups about what that would look like? Can you speak to any of the groups that you've spoken to who would be interested in participating in this sort of restorative community-based counseling, in addition to community service?
I have met with several groups. I actually started working on this when that Anderson decision came out in the fall of 2019. I've also met several times with the Attorney General's office. They have a division kind of that's working group on like all things related to battery domestic violence. I have talked with Liz Ortenberger, who actually I think will be testifying in opposition because she wants some of this other language and some of these protections that are already existing in administrative code to be incorporated. And like I had said before, I'm not opposed to that. I want to make sure that we can do it under the legal construct and also give discretion to our other elected leaders. Like we have judges that are elected. We have a different thing. As far as the restorative justice, it's not typically done in a battery domestic violence setting. It was something that I had looked into, but I understand the model that you're trying to look at, and this is kind of like a hybrid model. Unfortunately, this is not a black and white issue. And is this bill going to fix all of our problems regarding domestic violence in our state? Absolutely not. I think it is time for us to look at things that we've been doing and whether or not they work. And I would argue that they don't. And so I think we need to look at what we have been doing and what our organizations have been doing. Safe Nest is a perfect example. They keep their own data. They keep their own stuff. Like we don't even keep that data as a state. It's hard to collect information about racial and ethnic and gender inequities and arrest and treatment and that because we don't keep that routinely. So we rely on these community partners for their data, for their information. This is what they do. So, I really have been working with them trying to figure out how we can balance some of those judicial issues because it's different because you're in a criminal court. As well as protecting due process rights, protecting, our community, protecting victims and how we can do that. And, there are people that are going to be very uncomfortable with some of the provisions, but I'm dedicated to trying to do something. I think that's where we need to start. And as, most of the people on this committee know, it would be easy to say, hey, if you're victimized or you're a victim or you're a survivor, just leave that person. But sometimes you have a relationship with that person. You have children in common with them. People want treatment for their batterers. They want a holistic approach. They want their kids to not repeat this cycle of violence because they, either just did their time, they didn't complete a class, they did a one-size-fits-all model, and they maybe needed additional counseling and treatment because they have concurring problems. So I have met with them. I will continue to meet with them to try to get this language correct.
Thank you, Chair. Thank you, Chair. I have a follow-up question or at least a comment, but I do have a question as well. And thank you, Assemblywoman Nguyen, for acknowledging that there cannot be a one-size-fits-all. And I would hope that you would be able to, that when this court is set up, and I'm going to say when, because I'm hopeful that we can look into this, that we can also work diligently in including treatment programs that are culturally competent. I think that one size fits all does not work. And I think that we have to think broadly about how to bring people in to sort of mend these relationships and families. If they so choose to participate, at least the offerings to them would reach them in a place where they are and are culturally competent. My next question is about gun rights. So we had talked a couple of weeks ago or last week about domestic violence, and we had heard from the courts. You mentioned City of Henderson. How would this affect that? It's been several days. I've slept several times and tried to in between, and I can't quite remember if we talked about that there was some discussion about removing guns for domestic violence, and I'm not sure if it was misdemeanor or gross misdemeanor? If you could refresh and just give a quick overview of how this would bookend into that proposed legislation.
If you are charged and convicted of a misdemeanor first offense, battery domestic violence offense here in the state of Nevada, and it fits under that federal definition, you can no longer own, manufacture, ship, possess firearms or ammunition. So that is a federal prohibition. We have a state prohibition that the City of Henderson's bill is looking to also incorporate those people that are left out in, like in this example, like the dating relationship. So that's their bill, that's this bill. So that's current existing law. When I had reached out to legal during the drafting of this, and this is on the original bill, lots of things have to happen. One, you have to plead to the battery domestic violence. The court has to hear from the victim, has to hear from the prosecutor, has to hear from the defendant. They have to be accepted into this treatment program that currently doesn't exist. So once you get into that program and you complete that program, which most of the specialty courts are somewhere between 12 and 18 months, and then you complete that program, you would get a dismissal from your record. When it was originally written, I confirmed that you would have a full restoration of all of your constitutional rights, including your Second Amendment rights. That's kind of the carrot at the stick. If you do this complete program and you do all of this information and you complete the program, you get a complete restoration of your rights. I think that's in line with a lot of the specialty courts, that if you were doing this treatment, you were doing the things that you get it off your record, you get to do all that. Battery domestic violence is a little bit different, and I recognize that. And so I do have a question into legal on whether or not under the amendment, whether you still have that restoration, because it is a conditional dismissal because of these enhancing penalties that we have for first, second, and third offenses. So as soon as I find that out, I will let you know whether or not you also get a restoration of your Second Amendment rights under this new scenario, or whether or not there's a delay because of the conditional dismissal nature of this type of charge.
Thank you.
We'll go next to Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation, Vice Chair. So I have a couple of questions, if that's okay. My first one just has to do with the arguments. So for instance, in the amendment in Section 4, we're allowing for arguments from the parties. And I'm just wondering, is that just oral arguments at hearing? Is that a set motion, or is there written arguments allowed? Because I don't know the process for criminal court, and just kind of want to understand that more, how that's going to happen.
This is kind of in line with some of the provisions of Marcy's Law that give a victim a voice at sentencing, or at like crucial, like procedural, like dates in a criminal case. So this kind of just puts that into statute. Like currently, for example, if I have a client that pleads guilty to a battery domestic violence, and prior to the court sentencing them, they will say, are there any, witnesses or victims or victim advocates that are in the courtroom that would like to provide testimony prior to me making my sentencing decision. So I think it's just giving them the opportunity. I've seen people submit things in writing. I've seen people submit things orally. I've seen just like victims come in and testify, and they can testify however they choose to. In most of our courts, they are assisted with a victim advocate that is present there for supportive reasons as well. I've had people with family members come up and testify, however they choose to. So this is just kind of in line with what we already do, but it's specifically putting it in statute that it's something that can be considered, especially I think, let me pull up the amendment. this one says that the court can specifically take the safety of the victim as a factor in determining whether or not to assign someone to this program.
Okay, thank you. And is that, and I'm sorry, I can't find it now. But is that the same if someone is in the program and there's a question about whether or not they should remain in the program because of not complying, that type of thing? Is that also, or is that just oral arguments, or do they get a written motion practice as well? Or
in the current specialty courts, it's a little unique. You do, I mean, typically the way they work right now is there is a defense attorney in there and there is a prosecutor in there, but there's also counselors and caseworkers and other individuals that are a part of, like, they call it a treatment team. So it's a weird hybrid, like, criminal / specialty court treatment program. And I would align that with this. If you are looking to be terminated from a program, then you are entitled to some extra due process, like provisions, where, you know, prior to your termination from that process, you would be entitled to those. But as far as like discipline or restorative or like other things, the specialty courts use a lot of different things. Sometimes it's adding additional drug testing. Sometimes it's adding additional counseling requirements. Sometimes you'll have judges that have people write, like, you know, papers on like why they have things. Sometimes it's they have a lot of like flexibility on what kind of treatment and what kind of I guess punitive aspects of the thing. And so typically victims are not involved in that treatment process. But I'm not sure if that's laid out in statute specifically, but at any of the like crucial time periods, I would imagine people would be there.
okay, thank you. Yeah, it's a whole different animal for me, and so I appreciate that information. And then I also just wanted to touch on some issues you and I have discussed over the weekend, and I appreciate you taking the time to do that. And I'm sorry we haven't been able to reconnect on this, but I guess I have a statement more than a question. I just want to make sure that we're covering and considering child custody issues, because, you know, the state of Nevada has said that when you're dealing with child custody, the best interest of the child is the overriding factor. And I do have concerns that if we're sealing records, if we're doing dismissing cases, we're making it more difficult for the family court and the judges there to know if there have been convictions for domestic or what's the history with domestic violence, because it is such a big issue in the family law cases, and is a specific, you know, domestic violence is a specific factor when it comes to custody issues in making a custody determination. And while the civil judge, the family court judge, doesn't use such a high standard in a case, it's certainly, when that criminal case is open for the judge to know what happened, it certainly makes the process less time consuming and frankly, easier for the court, the litigants, to protect the child and the party who may have been the victim. So I just want to make sure we continue to look at that and see if there's some way to carve that out, do something to make sure that issue's still considered.
Thank you for your comment, and we did discuss this. I have been in communication. They reached out late yesterday afternoon to kind of work on some potential language that would facilitate some of the clarity issues in the family court. Like I said, we do have a provision there to conditionally dismiss the case if you're successful, and there is a balance. Part of the balance is if someone successfully completes such an intense program like these specialty courts are, there should be some benefit at the end of that, journey or process for them. And so I'm a true believer in the specialty courts and the power of rehabilitation in that area. And I would love to see that incorporated here. I recognize that there is some other issues and how these statutes relate to our current existing family court determinations. And so I think there are ways to make those records sealed. Like I said, they would be conditionally dismissed and retained by the law enforcement agencies just for enhancement purposes and things like that. So I think there is a way to incorporate that. So family court judges also have access to that within a certain time period. And obviously the individuals would be able to say, hey, I successfully completed this program and my charge was dismissed. So, yeah, I am looking into that, and I will continue to have those conversations.
Okay, thank you.
Assemblyman Orentlicker.
Thank you, Chair Yeager. Since putting in the request, I figured out the answer to my question, so I don't need to ask it. Thank you.
Thank you. Assemblywoman Krasner.
Oh, thank you, Chairman Yeager. My question relates to Section 4, Sub 2, where it talks about upon violation of a term or condition. So this is a two-part question. What constitutes violation of a term or condition, please?
So what will happen in a specialty court is they will set up like certain requirements. Usually they are somewhat individualized to, like, there's a general kind of like program on how a specialty court, and they're typically done in phases, like phase 1, phase 2, phase 3, phase 4, with more intensive programming and counseling and therapy and drug testing is up in the front part of that. And it corresponds out there. So if there are terms and conditions, so for example, on the consent, I think you're on Section 4 is what you said?
Section 4, Sub 2.
Okay. Are you on the amended language or are you on the old one?
I'm on the original language.
Okay. So let me see what Sub 2 is now.
You don't list Sub 2 in the amendment. That's why I went back to the original language.
Okay, hold on 1 second. Don't realize how invaluable. Okay, so 4, subsection 2. The court may impose sanctions against the defendant for a violation. That section right there?
So here's what I'm getting at. Number 1 in Section 4, Sub 2, it talks about violation of a term or condition. Could violation of a term or condition mean the person goes back and batters their wife again? That's the first part. That's the first question.
Typically what happens is if you violate the terms of your conditions and you pick up a new charge, you're going to be terminated from the program. And in this case, instead of having your dismissal at the end of the program, you've already entered a guilty plea to the charge. So you will already be adjudicated guilty of that charge, and then you could be sentenced accordingly. So on a misdemeanor battery domestic violence, if you would enter a plea, you plead guilty, the court would, do this assessment, send you over to a specialty court. Let's say during the specialty court, you commit a new crime or you're terminated from the specialty court. So you don't even have to commit a new crime. If you are just in violation, let's say you are not leaving urinalysis and they can't test you, or you're not showing up for counseling and they decide, hey, you're not taking this program seriously, we are going to terminate you from the program. You will go back. You've already entered your guilty plea. And so the court will then adjudicate you guilty of that battery domestic violence misdemeanor charge. And then they can sentence you up to 6 months in jail on that charge. So typically when you enter into a specialty court, you would have a 6-month suspended sentence hanging over your head. And if you do not complete the program, either you are terminated because you violated the terms and conditions of that, thing, or you went back and you beat up your spouse, and even if you don't have a conviction for it, they can still terminate you from the program. They can send you back, and then you just have your time imposed. So there's still that punitive, you still have the conviction, you still have like the court still have the ability to like sentence you based on your previous plea. Does that make sense, Assemblywoman Krasner?
Yes, thank you for your answer. And follow-up question, Chairman Yeager. So I appreciate that answer because it goes directly to my next question in section 4 sub 2A. After somebody violates a term or condition, perhaps beating up their spouse, battering their spouse again, the court may impose sanctions, but the person is allowed to remain in the program. Why would we allow them to remain in the program if they reoffend or go back and re-batter their spouse?
Terms and conditions can be a lot of different things. So as far as a treatment program, like a term and condition would be like, you were ordered to go to counseling on Monday, Wednesday, and Friday. And on Wednesday, you showed up 5 minutes late. And the counseling agency is like, if you're late, you're absent. And so you weren't able to attend that counseling session on the Wednesday. Let's say you had car problems. Let's say you had a bus and you couldn't make it to the counseling agency. Let's say you had any one of those things. That is maybe something that you don't terminate someone for, but that's a term and a condition. And so the court may want to impose a penalty. Sometimes that penalty could be like, hey, you didn't show up there. I want you to do some additional counseling, and that's your penalty. Sometimes your penalty could be, hey, I'm going to give you one chance. This is very important. You have to take this seriously. There can't be any excuses for why you don't show up for your counseling. So the terms and conditions can be lots of different things. If you leave a urinalysis, let's say as a condition of your specialty court treatment, you have to leave random UAs. That's what they were called, like in the courts. And you leave a urinalysis and it is diluted. So they can't test it because you drank too much water, okay? Should you be terminated from the program because they couldn't test your urinalysis that time? Maybe not. But should there be a penalty for violating that term and condition of the specialty program? Yes. And so this gives those judges an opportunity to look at what the violation is and determine whether or not that's someone they want to keep in the program or they want to terminate from the program.
So just a quick follow-up, then it is in the writing of the bill in, again, section 4 sub 2A, or what you're saying is that you don't want it to say the court may impose sanctions against the defendant for the violation, but allow the defendant to remain in the program. You want it to say the court will then have discretion to allow the defendant to remain in the program after violation of a term or condition. Is that what you're saying?
That's essentially what it is. Again, this is the language that's existing in all of the specialty court like statutes. So this is how all of our 30 or so specialty courts run off of this like same language.
I guess I'm just concerned because, again, it's somebody beating up their spouse. It's domestic battery. And this isn't really a right. It's sort of, a specialty court where we allow them to go so they have a clean record after this. And I don't know. I just have a few concerns about allowing somebody who goes back and rebatters their spouse to stay in this program where they're then getting their record right clean.
And, if I could jump in, Assemblywoman Krasner, I don't think if someone commits another battery, domestic violence, any judge in the state is going to allow them to remain in the program. I just think that's a pretty unrealistic scenario. The way I read the language, the court has two options under provision A. They can allow the participant to stay in the program with a sanction, or under B, they can essentially terminate the person and enter a judgment of conviction. So I think the language that's there with the may does give the discretion that both of you, I think, are speaking to. Maybe you're kind of speaking around each other a little bit, but I think that is the intent, and that's how every other specialty court program is structured. But I don't see any way where a judge would allow someone who commits the same crime to remain in the program. In my experience, it's just not ever going to happen.
I would agree. Thank you, Chair Yeager.
You're welcome. Do we have additional questions for Vice Chair Wynn? I'm not seeing any, Vice Chair. I just want to ask a couple super quick ones, so I'll go into cross-examination mode if you don't mind. But
I need it. I talk too much.
All of us lawyers can be guilty of that at times, so it's no problem. But I just want to confirm that Assembly Bill 339, as presented in the amendment, does not require any court to set up a specialty court program for battery domestic violence.
It does not. It is just purely enabling.
Thank you. And then the other question is Assembly Bill 339, as presented in the amendment, even if a court does set up a program, the court is not required to accept anybody into the program. That is a discretionary decision by the judge running the program. Is that correct?
It is completely discretionary. It is not mandatory at all on any parties to either have the program or refer people to the program.
Great. Well, I think that is it for my questions. And I think given the time, we ought to move on to some testimony on the bill. So Vice Chair Wynn, thank you for presenting. Ms. Salcedo, if you're still there with us, thank you for presenting as well. We'll ask the two of you to sit tight and let's take some testimony on the bill before coming back to wrap up. So at this time, I'm going to open it up for testimony in support of Assembly Bill 339. Is there anybody on the Zoom who'd like to testify in support of the bill? I'm not seeing any activity on the Zoom. BPS, could we go to the phone lines and see if there are folks there in support? I believe we should have a handful of them. And if that's the case, could we go to the first caller, please?
Thank you, Chair. To testify in support of Assembly Bill 339, press *9 now to take your place in the queue. And we will begin with the caller with the last three digits of 648. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Thank you, Chair Yeager, members of the Assembly Judiciary Committee. My name is John Jones, John Jones, and I'm here this morning on behalf of the Clark County District Attorney's Office. We are in support of AB 339 with Assemblywoman Wynn's proposed amendment. And I want to thank her for reaching out to us on this bill and having some constructive discussions with us surrounding this issue. Domestic violence cases are among the most serious cases prosecutors handle. At the Clark County District Attorney's Office, we have a specialized unit of prosecutors who handle only these cases. As Assemblywoman Wynn indicated during her testimony, there are a lot of dynamics at play with these cases, and having specialized prosecutors handle them helps us get the best possible outcome in each case. And it is important to note that this language is enabling, allowing each jurisdiction to make its own determination with an eye toward their own resources and community needs. It's also important to note that this only applies to a first offense battery domestic violence case. And even if the person goes through this specialized court, any future enhancements would still apply should the defendant offend again. Now, I want to take this opportunity to invite you to observe a day in domestic violence court. If you're interested in observing domestic violence court and meeting with a prosecutor who handles these cases, please let me know, and I'll make sure to set that up in the interim. But with that, Mr. Chairman, again, I want to reiterate we are in support of AB 339 with the amendment. Thank you.
Thank you for your testimony, Mr. Jones. BPS, let's take the next caller, please.
Thank you, Chair. We'll move on to the caller with the last three digits of 611. Please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. This is John Piro, Johnpiro from the Clark County Public Defender's Office. We are also in support of this measure. We'd like to thank Assemblywoman Rochelle Nguyen for bringing this forward and for bringing a new option for courts to use in order to combat this problem that we have in this state. Thank you.
Thank you for your testimony, Mr. Piro. BPS, let's take the next caller in support, please.
Thank you, Chair. Would the caller with the last three digits of 248 slowly state and spell your name for the record? You will have 2 minutes and may begin.
Good morning. My name is Mark Scifalacqua, M-A-R-C-S-C-H-I-F-A-L-A-C-Q-U-A from the City of Henderson, and I am the city's Chief Prosecutor. I'm testifying this morning in support of Assembly Bill 339. We believe that Section 10 appropriately restores the executive discretion regarding domestic violence cases. This is especially important since these cases, as you heard a few weeks ago, are now entitled to a jury trial. This will help ensure that the appropriate cases are proceeding to a jury trial. Also, as amended, sections 4 and 5 do represent a fair balance between victim and defendant rights in reference to treatment programs. We fully support the addition of a statutory mechanism for a victim to clearly voice their concerns to a court before a defendant can even be considered for the program, as well as excluding repeat offenders or those who proceeded to trial from assignment to the program. I want to thank the Vice Chair for bringing this bill, hearing our concerns, and the City of Henderson does support the bill as amended. Thank you, Mr. Chairman.
Thank you for your testimony, Mr. Skifalakwa. BPS, let's go to the next caller in support, please.
Thank you. Would the caller with the last 3 digits of 080 please slowly state and spell your name for the record? You will have 2 minutes and may begin. Caller with the last 3 digits of 080, press *6 to unmute to begin your testimony.
Sorry, I was muted. Jim Hoffman, Nevada Attorneys for Criminal Justice. NACJ supports AB 339 because it's a win-win situation. It's a win for offenders who can get the treatment they need to stop offending. And it's a win for victims in the community because, again, people get treatment, they're less likely to reoffend. I think you can see that by the fact that we have both defense attorneys and prosecutors testifying about why this is a good reform. And so with that, I would urge the committee to pass it. Thank you.
Thank you for your testimony, Mr. Hoffman. BPS, let's take the next caller in support.
Would the caller with the last 3 digits of 022 slowly state and then spell your name for the record? You will have 2 minutes and may begin.
For the record, my name is Sue, S-U-E, Meiske, M-E-U-S-C-H-K-E. I'm the Executive Director of the Nevada Coalition to End Domestic and Sexual Violence, and I'm here to speak in support of AB 339 as amended. We want to thank the Assemblywoman for meeting with us and listening to our concerns. The amendments that have been proposed go a long way in addressing our initial alarms about this bill, although some of my colleagues are not convinced and there may need to be additional amendments. When we first read the bill, before we saw any amendments, we were concerned. It seemed to provide for every court setting up a program to send all first-time defendants through a loosely defined program and have the charges dismissed. Adding to that, the removal of any requirement for a prosecutor to prosecute these cases, it seemed to roll back 40 years of progress in a single bill. And as a historical note, that requirement was added to NRS in 1997 at the request of prosecutors because of concerns that too many cases were being dismissed, not because a drink was spilled, but because of attitudes about domestic violence. We're certainly the first ones to admit that all the efforts we've put into this issue has not solved the problem. We see AB 339 as perhaps providing new tools to address the issue at the beginning and to address the co-occurring issues that are not causing the violence but are exacerbating the harm. For example, we know that victims can be prosecuted in cases where in self-defense they cause injury which is not identified as self-defense, or in frustration or fear they lash out and are the ones arrested. These might be the kinds of defendants that would be particularly suited for this type of court. What this can't be is a free pass or a get out of jail free card or a work around the ban against possessing a firearm if convicted of domestic violence. We completely agree with the Assemblywoman that there needs to be some process for data collection and evaluation that can tell us whether this works. Again, we are in support of this bill as amended. Thank you.
Thank you for your testimony, Ms. Meiske. BPS, are there additional callers in support?
There are. If you have recently joined the meeting and you would like to provide testimony in support of Bill AB 339, press *9 now to take your place in the queue. And we will go on to our next caller. Would the caller with the last 3 digits of 318 slowly state and then spell your name for the record? You will have 2 minutes and may begin.
Good morning. This is Kendra Birchie, Kendra,
D-E-R-T-S-C-H-Y with the Washoe County Public Defender's Office. Thank you, Chair Yeager and members of the Assembly Judiciary for allowing me to speak today on behalf of this extremely important bill. We appreciate Assemblywoman Nguyen for all of her hard work with creating an enabling statute for the specialty court. In Reno, the Reno Municipal Court currently allows for those charged with domestic violence to participate in their Veterans Court program. This has been extremely successful, where I can say that I have several clients who are participating in that program and are doing exceptionally well. It's connecting them to services, it's connecting them with opportunities, it's allowing them to obtain employment, housing, and the necessary medical attention that they need in order to succeed. The Second Judicial District Court specialty courts have a very high success rate. In 2018 to 2019, they indicated they had over 70%, and I believe it was over 70%, but at least for Veterans Court, it was a 77% successful completion rate. Even individuals who started a specialty court program but did not finish it still benefited from having been in the program. According to the Second Judicial Court's study in 2018, even if an individual failed to complete a specialty court program, the fact of their participation in a specialty court program substantially reduced the likelihood that an individual would commit another offense. In domestic battery, this is extremely important. As you've heard myself and Mr. Pirro testify over and over, we need to do something in order to address our offenders for domestic battery in order to ensure that we're no longer in the top tiers with these issues. And we truly believe that this is one of the ways that we can successfully accomplish of reducing our domestic battery cases by offering courts and opportunities to ensure that we are providing offenders with the appropriate treatment. Thank you for your time and attention today.
Thank you for your testimony, Ms. Birchie. BPS, if there are additional callers in support, please take the next one.
To testify in support of Assembly Bill 339, press star 9 now to take your place in the queue. Chair, there are no more callers wishing to offer testimony in support at this time.
Thank you, BPS. I will close testimony in support. I will now open it up for testimony in opposition to Assembly Bill 339. Is there anybody on the Zoom with us who'd like to testify in opposition to the bill? I don't see any activity on the Zoom. BPS, could we go to the phones to see if there's anybody there who'd like to give opposition testimony?
Yes. To provide opposition testimony to Assembly Bill 339, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 573. Please slowly state and spell your name for the record. You will have 2 minutes. Press star 6 now to unmute yourself.
Good morning. My name is Melissa Exline, E-X-L-I-N-E. Good morning, Chairman Yeager, committee members. I'm a family law attorney in Northern Nevada, and I work with the Nevada Justice Association. I'm here in opposition, but I'm looking forward to working with Chairman or Vice Chairman Nguyen and continuing efforts to make acceptable modifications as we proceed down the legislative path. Our concerns echo Assemblywoman Cohen's. AB 339 could have unintended consequences that does more harm than good to Nevada families. Specifically, this includes erasing or wiping out the underlying criminal act that led to the domestic violence charge. And while it's meritorious to look at addressing criminal issues in a way that helps the person charged when appropriate, we cannot forget about other legal implications and the further harm to a domestic violence victim. I had the opportunity to look at the amendment proposed by Vice Chair Assemblywoman Nguyen, and it helps, but it does not completely solve the concerns for protections of children and spouses from domestic violence as they are related to a custody action. In a custody dispute under NRS 125C.0035, the court must consider the best interest of children factors, and one obviously big factor to weigh is whether there was an act of domestic violence by a parent. If this allegation of domestic violence is raised in the family court, it can strongly impact the custody decision. The fact that a matter was admitted to or adjudicated in a related criminal case by the offending parent it directly impacts a custody matter, and it eases the generally hard to prove, often he said, she said factual situation. The accused party can still respond to the allegation and make his or her case before the family court, but the burden shifts this issue in family court, and this is very important to consider. The way AB 339 is written, the non-offending parent would be in an odd situation because the criminal actions are wiped clean legally. Even with the 7-year period before sealing applies, many family relationships and custody disputes have cascading and ongoing returns to court to address custody later on. There can be multiple interactions with police. A seal or a dismissal in this way could undermine the presumption statute that we look to in family court, and that the offender engaged in the act of domestic violence and then hamstring the victim down the road. Essentially, it could blind the family court judge from access to very important information. The act of domestic violence and considerations regarding whether this took place should not be subject to illegal erasure and thus victimizing the non-offending parent again. The proposed amendments are a good start. We are thankful to Assemblywoman Wen for being open-minded on this issue, and we're confident that she'll hear us out on this issue. But we were looking at the issue of examples of how the court gets information in other cases. So, for example, in abuse and neglect cases governed by NRS 432B, there is the ability of the court to keep records confidential, but we don't act like the underlying act didn't take place or fully wipe it clean from legal existence. Indeed, the family court judge appropriately may still learn that there has been an allegation regarding child abuse and neglect and subject to precautions to protect the accused. And the record is available with appropriate dissemination to the courts in certain circumstances. The key here that we want to focus on is just to make sure that the family court judge has the information in front of them as the trier of fact for a full and fair adjudication. So looking at the examples that were talked about, the drink on the head versus, punching your spouse in the face, these kind of this continuum of action and being full and appropriate and how that's considered. We just want to make sure as family court participants that the information gets to the trier of fact so that that person can make the right decision when custody is at stake. I've personally represented parents on both sides of this issue, been accused and denied things, or accused someone and been a victim of things. I can understand the idea behind carving out a process or a specialty court for this area. However, we'd like to see changes that might pull from NRS 432B that allows the judge to make the call to put the information in front of the court in evidence appropriately. Thank you for your time.
Thank you for your testimony, Ms. Exline. BPS, let's take the next caller in opposition, please.
Thank you. Would the caller with the last 3 digits of 650 please slowly state and spell your name? You will have 2 minutes and may begin now.
Liz Ortenberger, LIZORTENBURGER. I'm the CEO for SafeNest. Thank you to Chairman Yeager and the committee for hearing this bill today, and Assemblywoman Wynn for bringing it forward. As the largest provider in the state of domestic violence services, we are unique in that we are the only provider that works with survivors, batterers, and children affected by this epidemic. We see this from all sides, and we stand in opposition to AB 339 for this reason. Creating a subgroup of batterers treatment that the courts can implement without oversight of the already existing administrative code is contrary to what we've been working with, not only with the AG's office, but also including extensive research that's currently happening with UNR. In addition, restorative justice is being studied by UNLV in the domestic violence context, and none of that is included in this bill either. We stand ready to work with the Assemblywoman to correct this bill, but at no time should firearms be put back in the hands of a domestic violence batterer simply because they've completed classes. Thank you. We stand in strong opposition to Assembly Bill 339.
Thank you for your testimony, Ms. Ortenberger. BPS, are there additional callers in opposition?
To testify in opposition of Assembly Bill 339, press star 9 now to take your place in the queue. Chair, there are no more callers wishing to provide opposition testimony at this time.
Thank you, BPS. I'll close opposition testimony. I will now open it for neutral testimony. Anyone on the Zoom with us who'd like to testify in neutral this morning? I don't see any activity on the Zoom. BPS, could we please go to the phone lines and see if there's anybody there who'd like to give neutral testimony?
To provide neutral testimony on Assembly Bill 339, press star 9 now to take your place in the queue. And we will begin with caller. Please unmute yourself by hitting star 6 and state your name and spell your name for the record. You will have 2 minutes and may begin. Call in user number 1. There you go. State your name and spell your name for the record. You will have 2 minutes and may begin.
Hello, Mr. Chairman, members of the committee. This is Chuck Callaway, C-A-L-L-A-W-A-Y, representing the Las Vegas Metropolitan Police Department. We're here neutral today in the spirit of optimism on AB 339. As the Vice Chair said, not all domestic violence situations are the same, and domestic violence calls are the most dangerous, one of the most dangerous calls that our officers go on. We are bound by state law to arrest the primary aggressor when the primary aggressor can be determined. And about 20% of our homicides annually are domestic violence related. So this is a very serious issue and a very serious area. We definitely want people to get the help that they need, and we support programs that provide treatment and programs that end domestic violence. But we also want to ensure that potential abusers are not getting 2 bites of the apple, so to speak, and we want to ensure that victims are protected. I just saw the amendments this morning, and I'm still evaluating them. I've had conversation with the DA's office, which has provided me a level of comfort to come in today neutral in the hopes that we can have further dialogue in this important area. Thank you, Mr. Chair.
Thank you for your testimony, Mr. Callaway. BPS, are there any additional callers in neutral?
To provide neutral testimony on Assembly Bill 339, press star 9 now to take your place in the queue. Chair, at this time, there are no other callers wishing to provide neutral testimony.
Thank you, BPS. I'll close neutral testimony. I'll now hand it back over to Vice Chair Wynn for any concluding remarks on Assembly Bill 339.
I will just say, Rochelle Wynn for the record, I will just say that I will continue to work on any proposed amendments and continue to have those conversations with the stakeholders in order to get this bill correct. And I appreciate your support of Assembly Bill 339.
Thank you, Vice Chair Wynn, for your presentation this morning. And again, thank you to Ms. Salcedo, who did an excellent job testifying this morning as well. I will now close the hearing on Assembly Bill 339. Committee members, that takes us to our next item on the agenda, which is public comment. By way of reminder, we reserve up to 30 minutes for public comment at the end of each meeting. Callers on the public comment line will have 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature that are within the jurisdiction of the Assembly Judiciary Committee. BPS, could we please go to the public comment line and see if there is anybody there who'd like to give public comment this morning?
To provide public comment, press star 9 now to take your place in the queue. To provide public comment, press star 9 now to take your place in the queue. Chair, at this time, there are no callers who wish to provide public comment.
Thank you. I will close public comment. BPS, thank you again for helping us manage all the phone testimony on the bills today. We really appreciate it. Before we talk about the rest of the week, anything else from committee members this morning? Okay, I'm not seeing anything. Again, thank you all for being here on time and helping get through those bills this morning. I do have good news. We have a meeting tomorrow, but we're going to change the start time to 9 o'clock tomorrow. So you'll get an extra hour. So again, you can be here at 8, but I won't be here until 9. So if you want to show up at 9, we have a work session tomorrow. We're going to start with the work session at 9 o'clock. We'll get that document out to all of you sometime this afternoon, hopefully, to take a look at those bills. There shouldn't be any surprises there in terms of amendments, or just the amendments that were talked about in the various bill hearings. And then we do have a bill hearing tomorrow as well. So we'll take that second after we do the work session. So even though we're starting at 9, I would ask if everyone can be here promptly at 9 so we can get our work session done in a timely manner. And then for the rest of the week, we're still looking at what those agendas might look like as bills come in on the floor. So I don't have an update for you yet on Thursday and Friday. Most likely we will have Judiciary Committee meetings. I just don't know what time and which bills at this point. So thank you again, committee, for this morning. We'll see you back here tomorrow morning. Remember, at 9 o'clock, not 8 o'clock. So until then, have a great rest of the day. We'll see you tomorrow morning. This meeting is adjourned.